Hello, everyone. On behalf of the Federalist Society Student Division and the Hillsdale College FedSoc chapter, I welcome you all to tonight's Feddie Night Fight on state constitutionalism between the Honorable Stephen Markman and Clint Bolick. My name is Leo Schlueter, and I am the President Emeritus of the Federalist Society chapter at Hillsdale College. This, I think, is the first Feddie Night Fight to be hosted by an undergrad chapter, and I would like to extend a sincere thank you to Peter Redpath and the debate participants for making this happen. In particular, I would like to thank our moderator, Justice Brian Zahra, who I will now introduce. Brian Zahra is a justice on the Michigan Supreme Court, which he has been a member of since 2011. He has served on many professional and legislative committees, including the Michigan Civil Jury Instructions Committee, the Circuit Court Appellate Rules Committee, the Domestic Violence Legislation Implementation Task Force, the Advisory Committee for the Michigan Judicial Institute Domestic Violence Bench Book, and the Michigan Board of Law Examiners. Justice Zahra has taught as a Senior Fellow of Law and Public Policy at the University of Michigan Dearborn campus and is currently a Distinguished Fellow at Hillsdale College, right here in Hillsdale, Michigan. He has previously served on the adjunct faculty at the University of Detroit Mercy Law School and the Michigan State School of Law. I will now hand off the virtual microphone to Justice Zahra to introduce our fighters.
Thank you, Leo. It's really exciting to have a Feddie Fight night here at Hillsdale College in beautiful Hillsdale, Michigan. As you indicated, tonight's debate will be between Justice Stephen Markman, retired Chief Justice from the Michigan Supreme Court, and Justice Clint Bolick from the Arizona Supreme Court. There's a role for state courts and state constitutions in the development of American constitutional law. The breadth of that role will be discussed by our panelists tonight. The debate is entitled State Constitutionalism, Judicial Restraint, or Judicial Engagement. Justice Markman will make the case for judicial restraint, while Justice Bolick will argue in favor of greater judicial engagement. Each combatant will be given 20 minutes to present their case, followed by 4 minutes each for rebuttal. Thereafter, I will pose some questions to the panelists, and time permitting, we'll open the questions up to our audience. Justice Markman, you're on the clock.
Thank you, Justice Zahra, and thank you to the Federalist Society and to Hillsdale College for sponsoring this evening's event. It's an honor to participate with two such distinguished state jurists, our moderator and my debate partner. Although there are far more issues, I think, that unite Justice Bolick and myself than separate us, perhaps. Let me offer, if I might please, several random observations on our subject for this evening. Observation number one, what perhaps most unites Justice Bolick and myself is a shared enthusiasm for judicial federalism and for the revitalization of state constitutions. I favor these for the same reasons I generally favor the values of American federalism, the greater opportunities for legislative experimentation and innovation, a government that's closer and more responsive to the people, the dispersal and limiting of concentrated governmental power, and the freedom of citizens to vote with their feet for the society they prefer, to leave California and to go to Texas or do the reverse. Federalism, in my view, is not only sound public policy, but it's a public policy that runs throughout our United States Constitution. Observation number two, as with overall trends of American federalism, the trend of judicial federalism has long been in what I view as the wrong direction, toward greater centralized power within the federal judiciary, toward more uniform judicial policies, and toward diminished regard for the diversity and variety of our 50 states and their constitutions. These trends have not arisen by accident or happenstance, but largely as the result of specific decisions of the United States Supreme Court. As a result, undoing these trends, I believe, will also require specific decisions of the United States Supreme Court. Yet, over the years, I've seen little sustained interest for doing this, even when more federalist-oriented justices have predominated on that court. Observation number three. However, there are at least a few measures that state courts can take on their own to strengthen the role of state constitutions within our governmental architecture. For example, They might emphasize their openness to certified questions from federal courts so that the laws and constitutions of Michigan or Montana can be given meaning by the courts of Michigan in Montana, and thus the integrity of these laws and constitutions better maintained. They might more aggressively challenge lower federal court interpretations of their own laws and constitution with which they differ by contrary state court opinions. They might abandon so-called federal state lockstep policies in which state constitutional provisions are presumed to have the same meanings as counterpart federal provisions. They might also provide more thorough explanations for their criminal justice decisions in order to minimize federal habeas corpus reversals. They might more routinely cite as justifications for their decisions relevant state constitutional provisions, if only to remind the bench and bar that there are state constitutions that may be pertinent. And they may more frequently choose to invite parties and amici to present arguments concerning the significance of different language, context, or history of state counterpart constitutional provisions. These are all, in my judgment, appropriate strategies for state courts to take, for these courts remain the ultimate custodians of their own constitutions. More often than most judges do, Justice Bolick being an honorable exception, they must speak out on behalf of their own constitutions, as well as on behalf of the people of their own states who've ratified these constitutions and in whose name these constitutions were adopted. Observation number 4. In truth, however, I cannot say that measures of the sort that I've just mentioned have significantly revitalized our state constitutions. While in specific instances in Michigan, they have served to Michiganize our state constitution, I think that a balanced and larger view must recognize a different constitutional trajectory in our state and in most others. Within recent years alone, we've witnessed the federal constitutionalization of many areas of the law that were once largely Michigan constitutional concerns. That is, federal constitutional decisions that have replaced state constitutional decisions, giving interpretation to state Supreme Courts. We have such decisions from the federal judiciary nullifying or rewriting Michigan laws on such issues as electoral recount procedures, criminal appellate rules, sentencing guidelines, straight ticket voting, electoral integrity measures, sex offender registration, the advertising of local adult businesses, juvenile sentencing, state prisoner rights, state employee pensions, welfare entitlements, emergency municipal managers, affirmative action, legislative branch procedures, state redistricting, criminal procedures, and of course, laws defining marriage and its consequences. There was once a time in the history of our nation when a genuinely federal case was one whose impact would be felt far beyond the borders of a single state. A national commercial dispute, for example, a controversy with broad implications for interstate commerce, the interpretation of a comprehensive congressional enactment. Clearly, this is no longer the case. Observation number 5. Moreover, as I survey the larger judicial landscape of our republic, I see many aspects that are troubling to a person of Federalist inclinations. I see a stulting uniformity of state criminal laws and procedures, and perhaps soon as well, of criminal punishments as well. I see a thoroughly incorporated Constitution given principal definition by 9 persons upon a single judicial body, an immense concentration of power within a branch of government that long ago was described by our founders as our least dangerous branch. I see a line of demarcation in which federal courts decide issues of constitutional moment and state courts largely tort, contract, and common law disputes. I see a constitutional regime in which decisions of the US Supreme Court must regularly be scoured and scrutinized to ensure that each and every footnote and three-part test and passing reflection by a justice is elevated as the supreme law of Michigan and of 49 other states. And I even see law schools and bar examinations in which the study of state constitutions has increasingly become an afterthought. And in the meantime, I see 50 state constitutions that once defined the law of our land that now lie increasingly fallow and forgotten, part of a transformed and distorted judicial federalism. But as I've said, I do not know that there's much that can be done to revitalize these constitutions without some sense of deep concern by the Supreme Court that things have gone awry, and I have not yet seen this. Thought number 6. Nevertheless, I do have a few thoughts concerning how state courts might better maintain and seek to enhance the relevance and the force of what does remain within their own constitutions. In the final analysis, it's not merely the state constitution that must be strengthened, but even more state constitutionalism. It's not a conservative or liberal or libertarian constitutionalism that must be restored, but a constitutionalism that simply is faithful to the language and direction of our state constitutions, faithful to the intentions of those who've drafted and ratified these constitutions, faithful to the authority and the limitations of authority of the state judicial power, and faithful to the logic of the separation of powers, that it is not the role of the judiciary to say what the Constitution ought to be, but only what it is. Here are a few of my more elaborate thoughts, if I might share these. First, I do not believe that any different approach to the interpretation of federal and state constitutions is warranted. What is the responsible construction of one constitution is the responsible construction of the other, with the same rules and the same tools of interpretation properly employed. While there are distinctions between federal and state constitutions, I do not understand how these would warrant distinctive exercises of the judicial power. Furthermore, as Justice Frankfurter once remarked, the highest example of judicial duty is the subordination of personal will and private views to the law. And judges set this example by elevating constitutions above their consciences, by faithfully assessing the words of these laws in their context, the structure and organization of these laws, the larger purpose of these laws, their grammar, punctuation, syntax, comparable laws, and their proper legislative histories. And then the judge places all this evidence, all these textual clues before him or her, and inquires, what did the law reasonably mean to the people who were its drafters and ratifiers? What did they reasonably intend to communicate to later generations? This is not a mechanical process, and great judgment and experience is often required, but it is also not a free-for-all. And if it is the rule of law that we are seeking, and the rule of judges we are seeking to avoid, we must interpret our state constitutions, as with all other written law, in accordance with principles of original and reasonable meaning. Creativity and innovativeness may be the virtues of the legislature, but predictability and consistency are those of the courts and the jurist. Secondly, I do respectfully, but perhaps most of all, disagree with my colleague in his estimation of Justice Brennan's legacy of judicial federalism, by which state constitutions must be interpreted in accordance with the decisions of Justice Brennan, but may also be interpreted more broadly, although not more narrowly than has Justice Brennan. To me, this is all obvious, for the federal constitution is the supreme law of the land, and state constitutions cannot be in variance, but of course they are not generally invariants if they afford more rather than less constitutional protections to whoever or whatever Justice Brennan is protecting. More to the point, however, I and my conservative judicial colleagues on the Michigan Supreme Court were very rarely, if ever, enticed by the opportunity to expand upon what we viewed as Justice Brennan's dubious federal constitutional interpretations, say in Miranda or Mapp or Furman, with interpretations of our own Constitution that we viewed as being even more dubious and even further afield from James Madison's Constitution or from the language of our own state constitutions. If, for example, Justice Brennan discovered, as he did in Plyler versus Doe, a new federal constitutional right to a public education for children who are illegally in this country, that would not persuade all that many state judges to look toward their own constitutions to discern a new and broader constitutional right for such children, say, to welfare benefits or eligibility for student loans or a library card. Justice Brennan's supposed conversation with state judges simply never included those of us with traditional perspectives, judges who were not looking to expand the authority of the judiciary, but rather to preserve original and limited understandings of that authority and of the judicial power itself. By Justice Brennan's leadership in replacing state constitutional law with federal constitutional law during the era of incorporation, he was not, as I think he is in my colleagues' estimation, a pioneer in the revival of state constitutions, but a pioneer in their emasculation, where once state constitutions mattered greatly to the affairs of the states and the nation and served well to govern a great and dispersed people for the first century and a half of its existence. As a result of Justice Brennan's stifling theory of incorporation, in which every jot and tittle of his opinions had to be fully saluted by every state judge, his legacy is that those state constitutions now matter relatively little. Third, I'm also in disagreement with those who assert that state constitutions permit a distinctive judicial approach. Although as with regard to Justice Bolick, I am also a great admirer of Judge Sutton and his important works on state constitutions, I am again in respectful disagreement that state constitutions better serve to vindicate individual rights because state courts possess greater flexibility to interpret these constitutions in accord with their cultures, geographies, and histories. While the drafters of our state constitutions may certainly take into account distinctive cultures, geographies, and cultures, I would be far more respectful of these determinations than have been many federal judges. As an interpreter, as a judicial interpreter of these laws, I would not be inclined to give distinctive meaning to similar language in a similar context in, say, the Michigan and Oklahoma constitutions, just as I would not be inclined to give distinctive meaning to a provision of the Michigan Constitution in resolving a dispute, say, in Jonesville, Michigan, compared to what I would give it in resolving a dispute in the much different communities of Detroit, Muskegon, or Beaver Island. Fourth, I would not impose what I view as an erroneous interpretation of the federal Constitution upon a counterpart provision of the state constitution. After all, the premise of the Federalist Project is that the state constitution is a distinctive law and its ultimate interpreter is a distinctive court. While the federal Constitution remains the supreme law of the land, and its guarantees of particular rights cannot be compromised by state constitutions, this doesn't mean that when what the state judge views as a flawed interpretation by Justice Brennan or Justice Sotomayor, for example, must be replicated within the state constitution. For example, the so-called right of privacy was first discovered in the federal Constitution about 180 years after its ratification, and this right has since been relied upon to assert a broad range of newfangled constitutional rights having to do with such things as contraception, abortion, sodomy, grandparents' rights, and so forth. Nonetheless, in the absence of some genuine state authority for a right of privacy or these other rights, I would not extend a made-up right to the state constitution, wherein it would constitute an equally made-up right. While the state judge may be bound by the right of privacy interpreting the federal constitution, that is no reason for abusing their judicial power to give similarly inexplicable meaning to the state constitution. But to be honest, after I say this to you, I pause, for I can think of new things, some good things that I as a state judge could have done with the Michigan right of privacy. Perhaps I could have established a new right to homeschooling. Possibly too, I could have found grounds for limiting disclosure of personal information that could be required by state tax authorities. And possibly even I might have been persuadable that private colleges such as Hillsdale, which are independent and take no grants or subsidies from the government, possess some sort of constitutional right to be left alone by government. And perhaps as well, there might be other rights of privacy, such as the right to own firearms of my choice in my home, or to purchase medications and supplements for my good health without FDA approval. Indeed, such a right as the right of privacy may lead to a cornucopia of new freedoms, and I am an innovative and creative judge, perhaps. But, and then I think again, if such rights are to be enjoyed in Michigan, this should be done not by distorting and contorting the Michigan Constitution by a non-existent right of privacy, but these things, it seems to me, would be better done by the decision-making of our elected representatives through the Republican and Democratic processes of government. Is not, after all, the greatest legacy of our framers, the greatest legacy of our Constitution, its legacy of representative self-government, the repudiation of monarchs and autocrats. It's not the government by judiciary. I think, after all, that I will leave these decisions to the people and to their elected representatives to decide. In sum, I believe that the revitalization of state constitutions and state constitutionalism should not be built upon a mimicry of federal constitutionalism, that state interpretations of their own constitutions should be made independently of those of the federal Constitution, and that state judges, to the best of their ability, should accord faithful and true meaning to their own constitutions in accordance with their constitutional power. I thank again the Federalist Society and Hillsdale College for hosting this event. And of course, I thank very much Justice Bolick and Justice Zahra for their thoughtfulness and civility. Thank you very much.
Thank you, Justice Markman. Justice Bolick, you're on the clock.
Well, good evening, and it's great to be at Hillsdale, which is a true citadel of civil discourse and Western values. And I'm proud to be a guest of this incredible institution. And also, I have to say the Federalist Society for their promotion for this event. Markman and I have never looked this dynamic ever before, and very, very impressed with your graphics department. Justice Zahra, Justice Markman, Leo, really, really happy to be with you. State constitutionalism is the practice of independently interpreting state constitutions, and it occupies the intersection of federalism and textualism. Federalism, because we don't just have one constitution, we have 51. And in our federalist system, states have great autonomy to protect additional rights beyond those that are protected in the federal constitution, and to impose greater constraints on their government than does the federal Constitution. And textualism, because by our constitutional oath as judges, we're obligated to give meaning to every word in our constitutions, even if that places us at variance with other courts and even the United States Supreme Court. Every constitution, every single one, has provisions that do not exist in the US Constitution. Some of my favorites are gift clauses, anti-monopoly clauses, private or local bill prohibitions, that sort of thing. That if only the framers of the federal Constitution had the foresight to include those provisions, we might be better off as a nation. Many constitutions have provisions that are worded differently than their counterparts in the US Constitution. I think of free speech provisions, for example. Many states followed not the model of the First Amendment, but the model of early state constitutions, which provide an arguably broader right to free speech than is protected by the First Amendment. And of course, we are even free to interpret identically written provisions differently than the US Supreme Court interprets the counterpart provisions in the US Constitution. This allows us to be true to the original meaning of the words in both of our constitutions. Even if the US Supreme Court has departed from that original meaning, it doesn't mean that we have to. And in fact, as textualists, we should not do so. Many state constitutions do not have case or controversy requirements. And of course, we are free to follow or not to follow other prudential doctrines such as ripeness or mootness. And of course, most state constitutions are far easier to amend than the US Constitution. All of these features inspired William Brennan to write a pair of law review articles in the 1970s and 1980s, extolling the virtues of state constitutionalism. He did so, however, not as an originalist, quite the contrary, but as a matter of strategic necessity. He was losing the war after he had moved jurisprudence in a living constitutionalism direction during the Warren era. Suddenly there was retrenchment with the appointment of justices by Richard Nixon. And recognizing that he might be losing momentum at the very least, he encouraged liberal activists to repair to state constitutions to build upon the legacy that he had built during the Warren era. Now, what I credit Brennan for is not his living constitutionalism, quite the contrary. But I credit him for being the rediscoverer, for whatever reason, of state constitutions. And all of the things that he said about the distinctive features of state constitutions and the role that they play in our Federalist Republic were absolutely true. In fact, he proclaimed himself a Federalist. So at the very least, state constitutions encouraged Justice Brennan, who had not previously been a particular advocate of federalism, to become one, at least in this limited context. And I give him a great deal of credit because, you know, in the 1940s, the 10th Amendment was considered a truism by the US Supreme Court, and state constitutions really moved to the background. So much so that even today in most law schools, state constitutional law is not a requirement. It's not tested on the bar exam. And as the ABA is pushing to include mandatory subjects that shouldn't be required in law school, perhaps we ought to be talking about making the study of state constitutional law, at least on a state-by-state basis, a mandatory part of the constitutional law curriculum. We've only begun to scratch the surface of state constitutionalism, and Jeff Sutton's magnificent contributions to that scholarship are really valuable, and they underscore that this is not a liberal venture or a conservative venture, as Justice Markman mentioned. It really depends upon the nature of the provisions in state constitutions. Just to give you an example, the most state constitutions contain an explicit right to education. To me, that requires an originalist judge to enforce that guarantee. Does it mean that we have to take over school districts or order increased funding of schools? Well, many of us, perhaps all of us, agree that those sorts of things are not proper judicial remedies. But if the language is in the state constitution, even though it supports a liberal policy that is reflected in the state constitution, it's our job to enforce it. But I think we find far more provisions that many conservatives would like, because the framers of state constitutions, by and large, were very, very distrustful of government and were very protective of individual rights, and many of them built upon the lessons of the federal jurisprudence and mistakes that had been made. One of my favorite provisions in the Arizona Declaration of Rights is one that says that these provisions are mandatory. Well, you would only need that when you discovered that federal courts often didn't consider rights that were protected in the Constitution mandatory. And I find that a very good innovation. Well, we have only begun to scratch, as I said, the surface of state constitutionalism. What do we have to do to get there? Well, first of all, I think that state court judges need to accord primacy to their state constitutions, to consider state constitutions first. And that in turn will induce advocates to make serious arguments about state constitutionalism. We need more research on state constitutional provisions. And there, I really credit the Federalist Society for leading the charge in doing that. And most of all, we need lawyers to raise and develop state constitutional arguments. They're often leaving important tools on the table when they fail to do so. I certainly take Justice Markman's point about state constitutionalism potentially leading to Brennanism. I mean, that after all, that's why Brennan wrote those law review articles. But to give you one example of a case where an originalist would in fact find, in my opinion, greater rights under a state constitution was a recent decision by my court called State versus Mixton. It involved whether a warrant was necessary under the Fourth Amendment and under our state constitution's clause counterpart provision to obtain ISP data from a criminal defendant. We do have an explicit right to privacy in our Constitution. It protects the right of individuals to be secure in their private affairs except by authority of law. What those of us in the dissent did was to look at the meaning of those words when they were made part of our Constitution in 1912. And we discovered that the concept of private affairs was pretty well understood, and it was pretty broad. It even encompassed many business records. The Fourth Amendment, by contrast, has gone absolutely haywire. We have a decision that continues to be the lodestar that calls upon judges to determine what privacy rights society is prepared to accept. And the U.S. versus Katz decision, the Harlan concurrence, that's the law of Supreme Court jurisprudence. State Supreme Court justices do not have to follow in interpreting their own constitutions that kind of adventurous nonsense, and we shouldn't. But we should give full meaning original meaning to the words of our state constitution. And even if it means providing greater protection for the rights of criminal defendants than are recognized by the US Supreme Court. I want to conclude with my favorite example of state constitutionalism in action. And it's one that I know both Justice Zahra and Justice Markman appreciate, because the same thing happened in their states. Most everyone on this conference will remember the infamous Kelo decision, in which the United States Supreme Court, over the passionate objection of my fellow Arizonan Justice Sandra Day O'Connor, held that the public use limitation in the Fifth Amendment really meant public benefit, and that the bulldozing of a working class neighborhood to make way for private amenities for a Pfizer plant that was never built was justified under the Fifth Amendment. At the very same time that case was being litigated under the federal Constitution in Washington, D.C., we were at the Institute for Justice litigating a very similar case in Arizona under the Arizona state constitution. And the court ultimately, long before I was a part of the judiciary, correctly interpreted our constitutional provision to say that public use means use by the public, not transfer of property from one private property owner to another. What that meant at the end of the day was that a guy named Randy Bailey, who only wanted to be left alone to operate the brake service business that had been in his family for decades, could continue to do exactly that. Under the federal Constitution as interpreted by the Supreme Court, he would have lost. Under the Arizona Constitution, the Ohio Constitution, the Michigan Constitution, originalists looking for the plain meaning of those words vindicated them. That's exactly what we ought to be in business as state judges to do.
Justice Markman?
Thank you, Justice Zahra, and thank you, Justice Bolick. Appreciate your very thoughtful comments. And I recall the Nixon case, and I thought that was a very well-justified case under the Constitution of Arizona, which does have some particular provisions that are not contained, certainly not in Michigan's Constitution, but perhaps in some and not others. Let me summarize what perhaps most concerns me about the kind of state constitutionalism that Justice Bolick has spoken of tonight. And I emphasize it's not anything that Justice Bolick has said, but it's things that concern me about the larger precepts of that kind of state constitutionalism. And it's this: I would not employ our state constitution in the same search for what some have called the constitutional holy grail as has marked our federal Constitution. This is what the late and great constitutional scholar from the University of Chicago Law School, David Curry, once described as the discovery of a constitutional clause that allows judges to strike down all laws they dislike and to uphold or to require all laws they do like. That is the reliance upon broad and vague and boundless constitutional provisions removed entirely from their historical context and purposes. These provisions have often been relied upon to further the political agenda of those who'd like to impose their preferred policies upon the state and country without the inconvenience of having to persuade legislative and popular majorities. At particular times under the federal Constitution, we've seen the search for this constitutional holy grail by legal academics and some receptive judges focused upon the right of privacy that I mentioned earlier, broad and arbitrary protected categories of people under the Equal Protection Clause, the Ninth Amendment, fundamental rights theories under the 14th Amendment, substantive due process, novel understandings of positive constitutional rights and state action, rational basis analysis, and most recently, the Privileges and Immunities Clause of the 14th Amendment. These have in common the potential for interpretations of the federal Constitution that rely very heavily upon the consciences and preferences and personal discretion of the individual judge, and only slightly upon the actual intentions of their framers. That it is upon an individual sense of justice rather than justice under law. My concern is that the search for these same kinds of holy grail principles that have done so much to undermine state constitutionalism in the first place, with so many things having been federally constitutionalized under these precepts, that will now see two constitutions in which the same pursuit will be continued, and thus will have more and more judicial decision-making replacing the decision-making of the representative branches of government. We'll have more and more decision-making by a branch of government that's comprised entirely of lawyers instead of a branch that's comprised generally of we the people. We'll have a branch that's focused upon the kinds of things that would only be coming from a branch in which they were looking to impose more conceptions of the Constitution that couldn't be obtained by a straightforward interpretation of the Constitution. And I'm really very troubled by this aspect of what state constitution might potentially lead to if we don't impose the traditional interpretive process upon state constitutional decision makers, state judges, rather than allowing the same kind of expansive personal types of decision making that we've seen so much of under the federal Constitution. More than anything else, my concern is we'll have two constitutions in which things can be concocted and made up, as opposed to only one constitution in which that's the standard. So I guess I invite my colleague, Justice Bolick, to soothe my concerns there if he's able to do that. I really am troubled by these principles of the Constitution that have just been concocted in recent years, and in which judges look more to their conscience, more to their heart, more to their personal view than to what the language in the text of the Constitution has to say in terms of dictating the law.
Well, I'm not sure how much I'll be able to soothe you, but I will attempt to do so. Justice Markman and I do, I believe, agree on the vast majority of issues that would arise under state constitutionalism. But I have to say that anytime you want a real debate between the two of us, mention the words privileges or immunities, and the fight is on. So I thank you for doing that. So I kind of have the opposite concern, as well as the concern that you expressed, and that is a concern about the under-protection of constitutional rights and the under-enforcement of constraints on government power. Just to give you one example among many, many state constitutions have gift clauses that prohibit the use of public funds by subsidy or otherwise for the private benefit of individuals, corporations, or associations. I'm aware of only one state Supreme Court that has meaningfully enforced that guarantee, and that's my state constitution. In other states, all sorts of reasons are found to justify expenditures of public funds for the purely private benefit of a particular corporation or individual in the name of economic development and so forth, the kind of thing that doesn't appear in the Constitution and precisely the type of problem that was identified by the framers. So I do think, and privileges or immunities at the federal level certainly fits into that category. I could not agree more that there are no holy grails in either the state or the federal Constitution. I share Justice Markman's concern about, for example, due process. I teach in my constitutional law class that substantive due process is a contradiction in terms, and it has been used as a license for courts to establish all sorts of rights and limits on government that were not intended. One of the reasons why it has taken on such great meaning is that the privileges or immunities clause was deprived of any meaning in the slaughterhouse cases. And as a result, there was an effort to pack what was intended to be protected and then some into the far more ambiguous words of due process. So I think the only way to protect against the concerns that Justice Markman is expressing is to appoint originalist judges. And I think that we're going to see a very positive trend in that regard in the US Supreme Court. The court, by the way, Steve, and this is not a major case, but the court just granted review in a case from my court, a criminal case, that and rephrased the question that was presented to include to focus on whether there were independent and adequate state grounds for our decision upholding a conviction that might be troublesome under the current federal jurisprudence. I think they're expressing more and more interest in federalism, including state constitutionalism. We'll see where that case goes and others like them. But in the meantime, I think that state Supreme Court justices and other appellate judges need to abide their oath. And if they do, they will give the intended meaning to provisions that are in fact intended to protect individual rights and constrain government powers, while at the same time not creating things that don't exist.
Justice Bolick, thank you. I've been slightly becalmed. Concerning privileges and immunities, though, I agree with you. There's widespread disagreement shared by me with you that the slaughterhouse case was in error in its interpretation of the 14th Amendment. But I don't know that there's any agreement on what the proper interpretation of that amendment is. I think Bork calls it an ink blot, a Rorschach test. Scalia, the darling of the professoriate, and Senator Reverdy Johnson, during the debates over the Privileges and Immunities Clause, and a former Attorney General of the United States, was perhaps the most perceptive observer of all, who said on the floor, "I do not understand what its effect will conceivably be." And if you look at the standards of the modern professoriate reflected in hundreds of law review articles, there's also hundreds of different standards as to how that provision will be interpreted. So
Well,
he's going to have to remain irritated and concerned about that.
We'll give Justice Bolick an opportunity for Sir rebuttal, and then we'll get on to some questions.
only to say, you know, it was Elton John who said that Saturday nights are okay for fighting. The Federalist Society that introduced Feddie Night Fights, maybe they'll start a new series, and Professor Justice Markman and I'll be invited back to argue about Slaughterhouse.
Okay. I'll present my first question to Justice Bolick and offer Justice Markman an opportunity to respond as well. But what barriers are presented, if any, to the revitalization of state constitutionalism and judicial federalism by modern understandings of federal jurisdiction and federal constitution decision-making like the notion of substantive due process?
So I think this is an area of agreement between Justice Markman and me. I think the first barrier is ignorance, and that is that almost no one knows about their state constitution. I recently spoke at to a group of conservative activists on Constitution Day, and I asked them, how many of you support the Second Amendment? And every single hand in the room shot up. And I said, how many of you support Article 2, Section 26 of the Arizona Constitution? And one hand went up like halfway and then came back down. And you read the two provisions, and if you are an advocate of the right to keep and bear arms and could only choose one of them to protect you, you'd choose by its language, Article 2, Section 26, because it is rather unequivocal, unlike the Second Amendment's prefatory language. But if you don't assert these rights, if you don't argue about them, if you don't develop them, then they don't exist. So I think the biggest barrier is ignorance. But federal jurisprudence, and I think that Justice Markman's term, the federalization of jurisprudence and constitutionalism, is absolutely profound. And I think this court may be sympathetic to retreating from that to a significant extent, so long as state courts are doing their jobs in providing an originalist protection for their individual rights and not engaging in Brennanism.
I agree with Justice Bolick that ignorance on the part or unawareness on the part of the state bench and bar is one barrier to a restoration of state constitutions. I've seen in the courtroom advocates confronted with state constitutional provisions that may have been of benefit to their particular cases, rejecting these either out of unawareness of those provisions or simply a general lack of comfort with the state constitution. However, I think I would say that there are also very significant, substantial institutional barriers, most of all, in my judgment, these so-called holy grail constitutional provisions that we've seen in the federal context. These provisions almost overwhelmingly have accounted for the several dozen federalization cases I mentioned that have been undertaken by the federal judiciary in the state of Michigan. They're almost all predicated upon 14th Amendment principles, generating Section 1983 claims or substantive due process claims or rational basis scrutiny and things of that sort. And those have single-handedly, that one amendment, not exclusively, but almost single-handedly, is responsible for the transformation of large numbers of cases that once were the subject of state constitutional decision-making, now being transformed into federal constitutional decision-making. So until there's some kind of thorough review of the 14th Amendment, and there's many parts of the 14th Amendment that are obviously extremely critical parts of our Constitution, but there are also some parts that have been kind of picked out of the ether and given understandings and interpretations that are not clearly those that were intended by their framers. And I think they've accounted for a huge part of the transformation of our system of judicial federalism.
Thank you, Justice Markman. Justice Bolick, you mentioned that many state constitutions lack a case or controversy provision. Does that impact the notion of, does it provide a broader notion of standing or possibly a more narrow understanding of mootness or ripeness considerations?
Well, I think it really depends upon the particular state constitution, but generally, I think the answer is yes, and it certainly is yes in Arizona. And even beyond that, the idea of judicial review itself is not really made explicit in the U.S. Constitution. In many state constitutions, it is. And so we don't have to we don't have to blindly follow standing requirements or abide mootness or ripeness requirements. We consider them in Arizona prudential doctrines rather than constitutional doctrines.
Justice Markman, I get the sense you're going to disagree with that.
I think you're right. You predicted me accurately. We, in fact, in the Michigan Constitution, don't have a case or controversy provision that's similar to the federal provision. But we did have a case in the early 2000s in which that issue was presented before us, specifically the issue addressed by the U.S. Supreme Court, the Lujan decision. To what extent is the proposition of standing one of constitutional dimension? We concluded, I think correctly, that in Michigan, it was of constitutional dimension. That is, that if there was an absence of standing, litigation could not proceed, even though the legislature may have constructed a statute that provided for it proceeding under certain circumstances. Rather than having the case in controversy requirement, we do have two things that together substituted for that absence, and I think effectively so. One was the explicit judicial power that the Constitution did provide and that the federal Constitution provides, a judicial power that, as Justice Bolick is correct in saying, is not given great definition, as the concept of judicial review is not given great definition, but it is explicitly within the Constitution, and the judicial power is traditionally required that there be a case or controversy, and it's also required other things having to do with the justiciability of cases, such as ripeness and mootness criteria. Secondly, we have the logic of the separation of powers. And the logic of the separation of powers is that each of the branches has certain obligations. They can only carry out those obligations and authorities. They can use them to check and balance the other branches, but they can't invade upon the authorities of the other branches. We think that that provision also has implications and logical conceptions that allow us to reach the conclusion that in Michigan, at least, the case or controversy requirement is there. It's of constitutional dimension. And when the legislature enacts a law, an environmental law in our case, saying that anybody who feels that the law has been breached by anyone else in the state can sue that anyone else in the state, so that somebody from our deepest southeast part of the state, say Monroe, Michigan, can sue somebody who owns a lawnmower in the Upper Peninsula, which is emitting more fumes than it should be emitting. We've said, no, that kind of standing in the courtroom is non-existent, it's improper. Rather, there has to be traditional standing in which there's been a traditional injury and there's been a particularized harm that's been suffered by a plaintiff in litigation.
Justice Bolick, do you want to reply at all?
Only that, I think that the U.S. Supreme Court has narrowed standing even beyond what the concept of standing would allow. For example, not permitting taxpayer standing. And I think under a state constitution that has a great deal of provisions that limit the taxing and spending authority of the government, it's really, I would look at our Constitution structure and come to a very different conclusion than Justice Markman because one I think presumes that if there is an express limitation on the power of government, that there ought to be an actionable uh, 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 complaint that can be filed against it by people who are affected by it, even if it's a broad class.
Can I, sir, about you for just a moment, please?
Go ahead.
There's 100 million taxpayers in the country. How many of those would have an objection to any garden variety measure considered by the Congress? Probably at least several 100,000. Are we going to have created within our constitutional structure a legislative process that almost invariably will be followed by a judicial process in which the appropriation measures and the tax measures and the authorization measures will all be the subject of cases and controversies?
No, I don't think so, because you don't have very many provisions in the federal Constitution to enforce against that sort of thing, but you do in many state constitutions. And the one that I mentioned before, if you have a gift clause and a taxpayer can enforce it, it doesn't exist. You've repealed it by judicial inaction. And seeing that, certainly if the gift was being bestowed by the city of Tucson, I think as a prudential matter, our court or any Arizona court would say that a person in Flagstaff would not have standing to challenge that, but a taxpayer in Tucson who was picking up the tab for that would have standing, and I think that would be entirely appropriate.
Let's move on to another question. Should state courts apply a presumption of constitutionality to state legislation? Justice Mark, you want to start us off on this one?
Yes, I think Justice Bolick and I may not see exactly eye to eye this issue. Constitutional presumptions. Yes, I think constitutional presumptions are reasonable, specifically the presumption that when the legislature acts, what it has done is constitutional. Why do I think that presumption arises and is a reasonable one? Well, number one, the legislative branch takes an oath to abide by the Constitution, and I think that that oath needs to be given some respect. Secondly, the members of the legislature can read. They are generally literate, and I think that too should be taken into consideration, because our Constitution is not meant for lawyers and judges alone. It's meant for the people, and they can read the Constitution. And if it says that there'll be no breach of free speech or free exercise, they at least can understand what that generally means. Third, they're elected by the people, and that's entitled to some respect and regard. They're an equal coordinate branch of the government. That's entitled to some respect. They're a constitutional institution, the legislature is. That's entitled to some respect. And so too is the fact that by their oath, the legislature also is involved in the interpretive process. What only distinguishes them from the courts is that they're not the final decision maker in that process. But all these things together work to give at least a reasonable presumption that what the legislature has done is constitutional. It's rare that what they do is unconstitutional. It should be rare that what they do is unconstitutional, because they do speak for the people. So I believe that it might not be a strong presumption, but there is at least a threshold inference that what the legislature has done by its actions is constitutional. If it wasn't to be assumed constitutional, why would we let the law enacted by the legislature persist during the litigative process? That would seem not to be an appropriate default position, but typically that's the understanding. The law continues throughout the process, and it's only after it's struck down that we deem it to be unconstitutional or worth nullification.
Well, I respectfully disagree. I see behind Justice Zahra and myself the scales of justice, the most ubiquitous symbol of the American system of justice. And the presumption of constitutionality tips the balance in favor of government and away from the people whose rights are being regulated by government. I don't think that the framers of either the American Constitution or the U.S. Constitution wanted to rely on their elected officials to judge the constitutional boundaries of their own power. But whatever the case for the presumption of constitutionality at the federal level, I think that in many state courts, there ought to be no presumption, because when you read our constitutions, they tell us exactly what they are meant to do, what their purpose is. Many state constitutions, if not all of them, have preambular language, and the preambular language in the Arizona Constitution and many others say that the purpose of this constitution is to protect individual rights. How divergent is that from the notion that the moment you go into court to protect your individual rights, the government is presumed to win? That seems very inconsistent. And one of my colleagues and I wrote a concurring opinion in one of our cases saying that although we agreed that the government should prevail in that case based on its own merits, that we would not employ a presumption of constitutionality. Much of our jurisprudence is based on federal jurisprudence, and we said that we will take wisdom wherever we can find it, but we should first determine that it is in fact wisdom.
Well, whatever the preamble says about constitutional rights, it of course should be respected, but it should also be understood that individual rights are protected in alternative ways by the Constitution. One, of course, is the discovery of a constitutional right by a judge. Another, and I think an even more fundamental protection, is a system in which the people elect their own representatives and are entitled to a reasonable expectation that those representatives will take actions that will be given some regard and some respect by the other branches of government. So I don't see anything at odds with the preamble or inappropriate about courts thinking that when they see some measure coming in their direction from the legislature, far more often than not, it's going to be within the authority of the government. If it isn't, they will have the opportunity to say so. But I think it's incompatible with the equal standing or the relatively equal standing of these branches within the government for the courts to give no regard and no respect to the fact that the people that have been placed in the Congress or the state legislatures by we the people themselves are entitled to no regard, and it's 50-50 in every case. Maybe in the end that's what it'll be, or maybe in the end the legislature would lose, but in all my years on the court, I've seen so few instances in which what the legislature has done is unconstitutional, as opposed to simply against my taste. Things that I disagreed with, things that I found imprudent, things that I found even foolish, but they were so infrequently that the legislature that had taken an oath to the people acted in such an irresponsible way that what they did was simply against the grain of what the Constitution required them to do.
Well, you may be right about that in terms of the number of instances in which it happens. And I'm not sure why the government needs an additional thumb on its scale through a judge-made presumption of constitutionality. But I would say that one way in which the judiciary respects the legislative boundaries is if there are two readings of a statute, one renders it unconstitutional and the other renders it constitutional, and they are equally plausible, we should choose the one that renders the statute constitutional. We should not usurp that that prerogative. We also shouldn't make policy decisions, and I agree with you emphatically on that. But when you have a clash between, for example, First Amendment rights or the analog under state constitution, and a city that denies a permit on an impermissible basis, that sort of thing, why should there be a presumption that the administrators who made that decision did so constitutionally?
You're talking about administrative agencies. I mean, I think
well, they are part of one of the other branches of government. But I could come up with myriad hypotheticals there.
We had a. Oh, go ahead, Justice Markman.
Well, Clint, you talk about constitutional rights, and it's quite appropriate that you do that. I mean, that's a fundamental purpose of a constitutional system, that we do have rights. But I do have to get back to the ground A in saying that when we talk about constitutional rights, we have to understand that once something is deemed to be a constitutional right, it is entirely removed from within the democratic system of debate and discussion. That's an extraordinarily impactful thing to do, particularly when you're talking about a single judge sitting and deciding that what 430 or 535 members of the legislature and the people and the governor have all done is wrong. Now, that judge ought to act in accord with his own sense of judgment and his legal analysis of the Constitution, but it's a pretty remarkable thing for a judge to be doing that sort of thing. And I think somewhere in the balance, there has to be some regard and some respect given to the fact that these are constitutional institutions of the government, and until proven unconstitutional, they have the authority to undertake these kinds of conduct. I understand your argument, and you're very articulate, and your points are well taken. But I do think that the very light preference or presumption I would give in favor of what has emerged from the representative system of government is still the better way of looking at things. Not a strong presumption, but a light presumption.
Question submitted by chat, and I'm going to modify it just ever so much to address this current question that you're both on. Would either of you change your position if the legislation under review by the court is people-initiated legislation? In other words, through the exercise of direct democracy, where the people go put something on the ballot and say, we want this to be our law, and it becomes law. Now, when the court reviews that, would you give it deference, Justice Bolick, or Justice Markman? Would you give it less deference because it comes through a different process and perhaps is inartfully worded? So let's start with Justice Bolick.
So I would give it exactly the same, and that has been the consistent view of Arizona jurisprudence. There's two legislatures, the elected legislature and the people. And one might argue that, well, the people are acting organically as a body, and obviously they can amend the Constitution, and if they do, then that's obviously a different story. But if they enact a statute, they have to follow all of the procedures that attend initiatives. And they're subject to the same constitutional boundaries as the legislature. There's one peculiar aspect of Arizona law that makes us especially mindful of citizen initiatives. I don't think that it changes our perspective, but it certainly would not lead us to be more deferential. And that is, we have a constitutional provision called the Voter Protection Act. And anything enacted by the people can only be modified. It can't be repealed at all except by a subsequent initiative. It can only be modified by a supermajority vote of the legislature, and only then if it is in keeping with the original intent of the constitutional provision. That has led to some really, really big problems. You know, when the legislature passes a bill and it turns out that they blew it, they can easily change it. And there's technical amendments every year to legislation. Not so for citizen initiatives. And so that's made us, I think, probably diligent is the proper word in making sure that these initiatives are both procedurally and substantively in accord with the Constitution.
Justice Markman?
I agree with Justice Bolick. I would give it the same deference, but to me, the same deference is some deference. Like Justice Bolick, I would give it some deference, but I don't see any consequential significance in the fact that something is emerging directly from the people or directly from the people's representatives. And I do look about the law of Michigan, and I see many cases in which we have language along the lines that statutes are presumed to be constitutional. We have a duty to construe statutes as constitutional unless their unconstitutionality is apparent. All I'm talking about are presumptions of that sort, light presumptions, but nonetheless, some measure of respect given to the process by which those statutes have emerged. I'm not talking about rote judicial articulations. I'm talking about articulations of presumptions that arise from precisely the kinds of things I shared a few minutes ago: the separation of powers, the oath of office, the fact that the legislators can read and presumably want to act in accord with the language of the Constitution. All those things together, I do think, amount to a greater sense of regard being given to the work product of the legislature than perhaps my colleague thinks.
Let's go on to another question. What distinctions, if any, are there between federal and state conceptions of the separation of powers? Clint, you want to start?
Who goes first on that?
Would you like to start?
Sure. So, you know, we've both touched upon this, especially Justice Markman has, and this is one of the distinctive attributes of state constitutionalism. In most state constitutions, separation of powers is explicit rather than implicit, as it is in the federal Constitution. In Arizona, we have an entire article that consists of only one sentence devoted to separation of powers, and it says that no one branch may ever exercise the powers of another. I do not consider that a source of a presumption of constitutionality, because I think it's the judicial function, not the legislative or executive function, to determine the constitutional boundaries of the other branches of government. But I do see two very significant attributes of this that may go beyond the federal courts. First of all, the judiciary should never act in a legislative or an executive fashion. And that, in my opinion, limits our remedial power tremendously. And it means that we cannot rewrite statutes, can either strike them down or not strike them down, but we cannot alter the handiwork of the legislature. And as far as the executive and the legislature are concerned, they've got to stick to their own lanes as well. And I think there's been very interesting examination of the non-delegation doctrine and other doctrines that are beginning to gain a foothold at the federal level that may have greater resonance at the state level because of these very explicit limitations on exercising the powers of the other branches.
Justice Markman.
I have much agreement with Justice Bolick here. Again, we in Michigan have a similar provision of the Constitution, a very concise and straightforward provision that states that no branch shall exercise the powers of another. I do think that that concept is implicit in the federal Constitution. Were it not, you probably wouldn't see the kind of non-delegation doctrine that my colleague mentions here. But nonetheless, our state provision, and similarly probably Arizona's provision, kind of hit the judge over the head and say, don't overlook this constitutional protection. It's in black and white, it's explicit, and it's unlike the federal Constitution, where these things all are drawn from the implicit logic of the responsibilities of the three branches. So we do have a non-delegation principle, which means that among other things, that the legislature cannot grant or delegate its legislative powers to another institution of the government, including the governor. But the non-delegation principle is there in federal law too. It just hasn't been enforced for the past 75 years or so. We did take advantage of that provision in the Michigan Constitution several years ago in striking down a very, very broad grant of emergency authority that was used by our governor in the course of the COVID crisis to regulate a great many aspects of the economy and of society during that difficult time. So we basically took a principle that was there within federal jurisprudence, but largely defunct, and we gave it practical, real, and actual meaning. And we again struck down a very, very significant emergency act that had been used by the governor to gain a great deal of control over the day-to-day decisions of the people of the state of Michigan. So I think Clint is right that more explicit separation of powers provision is something that can perhaps be used in a more straightforward and direct manner by a court, because it is there in black and white, whereas everything is implicit in the federal Constitution, at least in that regard, but only slightly implicit.
Yes, Steve, that is a magnificent decision, and I commend both of you for it.
Thank you.
All right, well, it is Feddie Fight Night, so let's see if we can end on a question that is a little more divisive between the two of you. The United States Constitution is one of the more difficult to amend constitutions in the entire world. State constitutions tend to be much easier to amend. In fact, I think most provide for amendment by vote of the people. Should the easier amendment process impact how state judges interpret their state constitutions? Steve, why don't we start with you?
Yes, I think about that question. I think, that maybe somewhere you've got a judge who's looking at his state constitution and thinking that it's fairly easily amendable, and therefore just less concerned about getting it right. Well, I'll do my best to get it right, but after all, the people can always overturn me or second to guess what I've done, and it's all pretty easily done here, where they can pursue the referendum process or the initiative process, or just simply employ a much more facilitated constitutional amendment process. I don't know that that's the way that a judge ought to approach his responsibilities any more than I think that a member of the legislature should say, as many have in fact said over the years, well, I don't know if what I'm voting for is constitutional or not, but I'll let the courts decide that next week. I don't think that's right, because they have, as I mentioned a few minutes ago, each taken their own oath of office to uphold the Constitution, and they shouldn't be laying that entire responsibility upon the courts. So unless there's some other aspect of the easy amendability of a Constitution that I'm overlooking, I don't see why that should make any difference whatsoever in distinguishing between how a judge should approach his or her interpretation of the state constitution compared to the federal Constitution. But perhaps I'm missing something.
Well, I wish our friend Judge Jeff Sutton was here to answer this question, because he presented this argument in his most recent book. And it was the first time I had heard this argument. Brennan points out that states can more easily amend their constitutions, but it's not meant to give judges more latitude to err, but simply that they are documents that are more subject to change, and to reflect the values of the people and that sort of thing. So I agree entirely with Steve on this. I don't think it's going to or should affect what a judge does at all. Jeff Sutton did make the flip side argument, though, and that is that because the US Constitution is so hard to amend, that US Supreme Court justices ought to be especially careful in their constitutional interpretation, because there's no way to really overturn their decisions. And I certainly agree with that proposition, that they ought to be very, very mindful that they should not go beyond what is expressed in the text, because when they do, when they take license like that, there's almost no way, other than electing a new president and eventually having a new Supreme Court, that you can correct those kinds of errors.
It's very interesting. I think you and Judge Sutton certainly have the better part of that argument, but it is ironic that there are many federal judges or observers of the constitutional scene generally who think just the opposite.
Yes.
Precisely because it is so hard to amend the Constitution. We need to let it breathe and be flexible through some other means, and those means are generally judges engaging in some aggressive exercises of constitutional interpretation.
Well, I thank you both. We're near the end of our time. I thank the Federalist Society for allowing us the opportunity to present this debate as a Feddie Fight Night event. And thank you both for your participation and your thoughtful comments on this subject. And I'll hand it back to Federalist Society Hillsdale chapter, student chapter member Leo Schlater.
All right. Thank you, everyone, for tuning in. And a very special thank you to our participants for putting on a fantastic example of what civil, well-reasoned, and very thought-provoking dialogue looks like. If you guys enjoyed this battle of wits, you should definitely plan on attending FedSoc's special second annual Star Wars themed Feddie Night Fight, which will take place on, of course, May the 4th at 10 o'clock p.m. The title of that Feddie Night Fight is Attack of the Clones on the Legitimacy of Cloning. And hopefully we'll see you all there as well. Thank you so much for tuning in, everybody.
you.